Well, welcome and congratulations for making it in the top 12. That in and of itself is a significant accomplishment that you should be very proud of. As John said, we will introduce ourselves first, and then if you would introduce yourselves. My name is David Hudson. I'm a law professor at Belmont University in Nashville, Tennessee.
I'm Hank Chambers. I'm a law professor at the University of Richmond. It's good to see you all. Been at this for a long time and used to seeing folks from Oregon.
And I'm Ben Glickman. I'm an attorney with the California Attorney General's Office. I'm also an alumnus of this program. I was at the national finals way back in 1995. So I'm looking forward to our conversation. If we manage to stump you, just hold real still and we'll think Zoom froze.
Hi, we are Unit 5 from Grant High School in Portland, Oregon. My name is Ava Phillips.
I'm Talia Baskin.
I'm Zoe White.
I'm Makoto Powers, and our teacher is Ms. Dee Pasqua.
Well, welcome. We'll begin the follow-up section now. I will read the question to you, and it's question number 1 in Unit 5. A result of the decision in Wisconsin v. Yoder is that, quote, any parent guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? And finally, how have courts balanced religious beliefs with other rights?
We do not agree with the holding in Wisconsin v. Yoder. We believe that the law in Yoder was sufficiently narrowly tailored to address the government's compelling interest in ensuring that all children have a high school education. Furthermore, Yoder only addressed the religious objections of an Amish sect to compulsory high school education and did not hold that a parent can remove a child from school if they objected to the curriculum on religious grounds. Rather, the Amish Heritage Foundation argues that this may be a future holding. This case represents the tension between the free exercise clause of the First Amendment and education rights.
The U.S. Constitution does not mention education, and the court ruled in San Antonio v. Rodriguez that education is not a fundamental right. However, both states and the federal government have grappled with equal access to education. The court has protected education in some controversial areas, such as Brown v. Board of Education, Plyler v. Doe, and Grutter v. Bollinger. Because of the 10th Amendment, education decisions are primarily up to the states, and all 50 states have some form of an education provision in their constitution. However, the contents of these provisions differ drastically from state to state. Alabama's constitution includes a provision for segregated schools. Washington's requires the state to fully fund education, and Virginia and Illinois call for high-quality education.
This right to education clashed with the right of freedom of religion in Yoder. The First Amendment right to religious freedom is split up into two main categories, the Free Exercise Clause and the Establishment Clause. In Yoder, the parents made their claim using the Free Exercise Clause. The Free Exercise Clause protects individuals from government interference with the practice of their faith, but the interpretation has changed frequently from the generally applicable law test in Reynolds v. U.S. to strict scrutiny in Sherbert v. Verner, and then back to the generally applicable law in Employment Division of Oregon v. Smith. In response to this change, Congress passed the Religious Freedom Restoration Act in 1993, which applied strict scrutiny to the issues of religious freedom for federal cases.
Courts have struggled to balance the First Amendment freedom of religion clauses against other rights. In many cases where two rights are in conflict, the Supreme Court has used procedural examination to avoid choosing one right over another. In Masterpiece Cake Shop versus Colorado Civil Rights Commission, the court declined to address the conflict between the Free Exercise Clause and an anti-discrimination statute, and instead decided the case on procedural grounds. On numerous occasions during the pandemic, religious rights have conflicted with COVID-19 restrictions. Recently, in Tandon v. Newsom, the Supreme Court favored a religious claim over the compelling government interest for public safety. In Yoder, we think that the court improperly prioritized religious freedom over the importance of a uniform, quality education for all. We agree with Chief Justice Warren in Brown versus Board of Education in that education is required in the performance of our most basic public responsibilities. It is the very foundation of good citizenship. We believe that the court should have placed the educational rights about the religious objections raised by the Yoders and kept the students in school. Justice Douglas wrote in his dissent in Yoder that if a parent keeps his child out of school, then the child will be forever barred from entry into the new and amazing world of diversity that we have today. Thank you. We're ready for your questions.
Excellent. You mentioned strict scrutiny in your opening presentation. Justice David Souter once wrote, quote, "Strict scrutiny leaves few survivors." What's the importance of the strict scrutiny standard in protecting constitutional rights?
Strict scrutiny is extremely important in protecting constitutional rights because it's kind of the top level of scrutiny, or it is the top level of scrutiny that we have. And in order for to pass strict scrutiny, you need to have a compelling governmental interest, and it needs to be narrowly tailored.
Especially in cases of religion, strict scrutiny is important because it's used when religion is being targeted and is being discriminated against. So they apply strict scrutiny so that they have a higher protection.
I believe the case Zoe's referring to is Church of Lukemi Babaluai v. City of Hialeah, where they established this test for strict scrutiny when religious rights are being targeted. But Employment Division of Oregon v. Smith established the generally applicable law test. So in cases of religion, that is the test that is supposed to be applied.
However, many states have a RFRA, a Religious Freedom Restoration Act. In our direct, we mentioned the federal RFRA, which was ruled unconstitutional in Bourne v. City of Flores. However, many states have passed their own RFRAs to make sure that religion is viewed through the strict scrutiny lens.
I think it's important to note that many people disagree with the state RFRAs. George Takei said that the Indiana RFRA was bigotry cloaked as religious protection. And the reason that he articulated this is because a lot of times when strict scrutiny is applied to religion, the courts value it more than any other kind of right or protection for other minority groups.
Shouldn't religion win over general government laws if it's actually a right under the First Amendment?
We don't think that religion should have total authority over government laws. In Employment Division of Oregon v. Smith, the court held that the generally applicable law that said you couldn't use peyote was generally applicable, and because of that, you couldn't have a religious exception. We think that in today's society, the court would have ruled the other way in Wisconsin v. Yoder, because we view education as more important now than we did in the time when Yoder was decided.
And you all think that that would have been a proper result? To go in the opposite direction?
Are you,
yes.
You're referring to, yes.
Yeah, okay. I'm curious, what if the folks in Yoder had said, we're going to pull our child out to homeschool the child in the Amish way? How should the court deal with that kind of situation?
I think that if the family were to pull the child out and follow homeschool curriculum, I think that that would be acceptable, because even as when parents homeschool their children, they still have to follow a curriculum provided by the state. Whereas the Amish wanted to take their children out and put them into an agrarian form of education, which did not follow the curriculum that is designed by the state.
At some point, would that state regulation become too burdensome?
Although it would substantially burden the religion, I think that the compelling government interest for education and for the child's substantive due process right to education kind of wins out here. And even since the founders made the Constitution, Benjamin Franklin said that an investment in knowledge pays the best interest, and I think that that's true for our society today. And even though that might kind of burden specific groups, I think it's important that the government kind of makes priorities, even though sometimes these might come into conflict with other rights.
You mentioned the Tandon decision in your prepared remarks, and you've talked a lot about Smith. Can those two decisions be reconciled with each other, or are they in conflict?
They are in conflict. In Tandon v. Newsom, although the court didn't explicitly say this, they use something called most favored nation theory, which says that if you provide an exception for one sort of activity, then you have to provide an exception for all activities. In this case, the court compared a grocery store being open to, and said that because this exception from a housing, you could only have 3 households congregating. They said that because you have an exception for grocery stores, you must provide an exception for religious groups that want to worship in their households.
And this is kind of a more extreme version of the Roman Catholic Diocese of Brooklyn, New York v. Cuomo decision, which happened just a little bit before, where, but in this case, the court was comparing kind of 2 more comparable activities. So in the Tandon v. Newsom dissent from Justice Kagan, she said it was like comparing apples to watermelons.
I do think.
And so have they gone too far then, in your view? The Supreme Court, have they protected free exercise to such a degree that they're now favoring religion?
In both of these cases, I think that they are favoring religion. We see the conflict of public health and religious freedom come into play and rule in favor of religious freedom. And I think that the government has a compelling governmental interest in public health to reduce the spread of COVID. And I think, as we've seen, over 500,000 people have died in this pandemic, and seeing them favor religion over the people that have been the victims of COVID is very upsetting to me. And I think that they have gone too far.
I think it is important to note that in Roman Catholic Diocese versus Cuomo, the statute put into place by New York was targeting religion. And so while we wish that they maybe, if New York had put into place another law that didn't specifically mention religion and wasn't specifically targeting religion, then it might have passed the Supreme, or it might have won out.
James Madison wrote once that liberty may be endangered by the abuses of liberty as well as by the abuses of power. And even though that was referring to something different, I think it applies in this situation, because if one right is valued more than kind of any other right in any situation, I think that becomes just as dangerous as if rights are limited, because in effect it does the same thing.
Let me ask you this. Sometimes the government grants exemptions, religious-based exemptions, to accommodate religion in order to comply with the free exercise clause. But at some point, when the government grants these exemptions to comply with the free exercise clause, are they not impermissibly advancing religion in violation of the Establishment Clause?
This is a question that was raised when 2 rights come into conflict, one of them being the free exercise. For example, in Masterpiece Cake Shop, there was an anti-discrimination statute going up against a free speech / free exercise claim. And the court held that, in this case, they went against the case due to procedural reasons. But people raised the question of, if the baker wasn't religious, would the court have still protected that speech? And many people think no, and that because he was religious and used this free exercise claim, he had a higher level of protection against the anti-discrimination statute than someone who wasn't religious.
So what do you do in that case? Weren't we talking about a generally applicable public accommodations law?
In which case?
In Masterpiece.
Oh, yeah.
Yeah. Okay. So should there have been any application of religious tests at all in that circumstance?
I don't believe that there should have been application of this test. I think that with an anti-discrimination statute, it's another situation where, in order for the compelling government interest to be achieved, it kind of has to apply to everyone, or it doesn't really have a purpose. Like if people can get out of the anti-discrimination statute regulations with a religious claim, then it kind of loses all its weight and meaning in our society.
I think that in this case, it comes up where if this cake bakery says no, why can't they just go to another one? But I think the point is that if they're able to make this exception for religion, then all of these cake places will be able to make this exception. And so that's why it cannot be ruled that way.
Should parents be allowed to stop schools from teaching certain subject matters to their children?
I don't think they can. Although in Myers v. Nebraska and Pierce v. Society of Sisters, the court held that parents do have a substantive due process right to control the education of their children. I don't think that they can deny something that's taught at school. They can take their child out of those subjects, but I think if they're against some subject that's taught at school, there's not much they can do about that.
Okay. Is it appropriate for them to even be able to take their child out of a particular class, do you think?
I think it is appropriate for them to take their child out of a specific class. In Myers v. Nebraska, this sorry, can I finish?
I thought, yeah.
I meant to say in Pierce v. Society of Sisters, this same kind of issue came into play. And I think that while the children's life will be advanced by going to the class, the adult should be able to take their child out if they wish to do so.
All right, thank you.
Great job. We'd like to recognize the students for their hard work and participation.
Yeah, great work. Would one of my colleagues like to start off the feedback?
Sure, I can start off the feedback. Good discussion, right? We had a good discussion, starting with the opening statement, right? The structure that you provided and a lot of the examples that you provided got us into the concepts. Of course, there are overlapping and interlocking and conflicting concepts. And that, of course, is what we then got into in the Q&A. When we hit the Q&A, there were sort of a couple of circumstances where we asked you particularly difficult questions. And we asked you some questions not about what the law is, but what the law might be and how you might well deal with them. And that's where the real fun comes in terms of allowing you all to show us what you've been thinking about and not merely what you've read. And that's the part that we had fun with. At least that's the part I had fun with. So I was really happy with that conversation and with our discussion sort of moving forward. So you all showed some technical skill as well as some ability to think on your feet, and that's what we like to see.
Yeah, I would agree. I thought, not surprisingly, the prepared remarks covered the question and answered all parts of the question. I appreciated the notion that it's so difficult to balance these things. They try to avoid doing so by kicking them on other grounds, which is accurate, of course. And then you also mentioned the Tandon decision, which is just a couple weeks old, which was good. And then later on in the Q&A, when I came back to that, I appreciated our discussion of that. And your ability to articulate what the decision was about and kind of what the criticisms of it are by Justice Kagan and others. I mean, it seems the way that answer might have been improved is if you had directly tied it back to Smith, because one of the challenges, so full disclosure, I worked on the Tandon case, but one of the frustrations we have with the Supreme Court's decision is that was a truly generally applicable law. It was, no gatherings of more than 3 households in a private home, period. And if that isn't triggering the rational basis scrutiny under Smith, what is? And it's very difficult to know where the lines are now. And that's why I asked, I wonder if they've effectively jettisoned Smith, if not in word, in practice. And so that's a topic for the future. But overall, whatever we threw at you, you were able to answer, and it was a really engaging conversation. So I appreciate it.
I echo the comments of my colleagues. As Judge Chambers said, it really was. We asked some very tough questions, and we really enjoyed the conversation with you. And I was particularly impressed with your structure, the way you set it up, and you displayed a really good, thorough understanding of the underlying constitutional structure and standards of review that we use in constitutional law, and you were able to apply those with some pragmatism. I was also particularly struck, I have to mention, the ability to pluck out an apt Ben Franklin or James Madison quote from Ms. Baskin. That was incredible. But it was just really a pleasure for us to engage in this conversation with you. And we all sincerely hope that you'll continue your study and appreciation of the Constitution. And we sincerely appreciate how much hard work you've put in on this competition.
Thank you.
Thank you.
Congratulations again.
Good luck.
Very impressive.
Thank you so much.